I'm here to talk about some changes to the work health safety legislation, in particular concerning psychosocial hazards and the right to disconnect. Sounds like a very dense topic, and I'll try and get through it without spending the rest of the day on it. The reason we thought this was a worthwhile update is because in October last year, the government made a series of changes to the Work Health Safety Act to introduce as a mandatory provision the consideration of a code which has been floating around since 2021 relating to the management of psychosocial hazards in the workplace. I'm sure you're all familiar with the WHS legislation. But the concept of what is a workplace is pretty broad, and these days can include people's work from home locations, remote locations. If they're in the car, it includes when they're travelling. So there's a pretty broad application of the Act. It applies to everyone. In one sense, for the purpose of the Act, everyone's responsible for everyone else's safety, and this is one aspect of it. The WHS Act defines health to include both physical and psychosocial health and psychological management. So this is an area of law which is evolving and is continuing to evolve. And so the government has made some changes after having a code around for a number of years, both at a state and federal level. So what actually is psychosocial risk? So it is very short, a risk manifested by a workplace situation that could lead to stress. And everyone responds to stress differently. Everyone responds to workplace incidents differently. And the key role of the employer here is to try and ensure or limit the occurrence of mental or physical harm as a result of a psychosocial stressor. I've listed on there some of the more common psychosocial hazards. These are things that the code specifically has got consideration of. There's a lot of detail in the code. I'm happy to share the actual content of the code later on if anyone would like it. It's about 40 pages long, so there is quite a lot of detail in it and quite a lot of steps that organisations can take in order to go through the management of these hazards. So obviously bullying and harassment, role overload and job control are common complaints that many organisations face, and we've seen now new risks posed from the isolation of remote workers and work from home situations, the risks posed by working in remote areas and the travel associated with workers in remote areas and travelling between job sites, particularly remote job sites where travel can be hours between one work site to the next. And also the implementation of AI work practices, so such things such as performance trackers, automatic rostering, all the applications that are associated with that, they pose their own risk in terms of job control and psychosocial risks that might manifest from people feeling stress as a result of an AI performance tracker like keyboard logging and tracking their performance in the workplace. So it's an emerging area through some of those technologies as well. The areas of people at risk is not defined. There's obviously a pretty broad category of employees within council's organisations. The type of work where there are high levels of stresses, so Safe Work New South Wales has identified healthcare, construction and education as being three areas where there are high levels of stresses because of the demands of the occupation itself. It's not limited by any means. It can and potentially will affect any worker in the workplace. So it's mindful that Council has got appropriate and robust policies to deal with it. The impact that's being faced now is that 1 in 5 complaints involve a complaint of a psychosocial subject matter. So it is quite significant in the modern workplace, and quite significant in dealing with grievances, that they are a significant proportion of overall complaints, and they are the most expensive form of workplace injury for compensation payouts. And I think that's quite significant move from where things were at even 10 and 15 years ago, and where AI and remote working takes us. If this trend continues, it'll be by far and large the largest contributor to claims. The code identifies a number of steps that organisations should take to manage workplace stresses and reduce the potential for workplace incidents. So there's 6 steps there: identify hazards, assess risk, control risks, review control measures, responding to the report of a risk, and supporting a safe return to work. I'll go through some of them in a little bit more detail, but it is important that organisations have robust policies in place that allow managers and key decision makers the ability to go through this process, starting with the identification of risk all the way through to supporting the return to work of an employee who may have suffered a workplace incident. So psychosocial harm stems generally from the way tasks or jobs are designed, organised or managed, where there are inherent psychosocial hazards. So in the healthcare space, people dealing with trauma, people dealing with abuse, all of those type of things inherently lead to the potential for the person dealing with it to suffer harm themselves. Physically demanding, hazardous work can lead to psychosocial harm. Factors within the organisation, so bullying, harassment, workplace interactions, and then other organisational contexts such as workplace overload. People frequently complain they've got too much on their plate, not enough support, not enough people in the team, being asked to do work outside of what they perceive to be their role, outside of what they perceive to be their KPIs, changing of KPIs without appropriate communication. So all of those type of context things can impact someone's ability to perform within the organisation and potentially lead to a claim relating to psychosocial harm. So what should organisations do? So the first step is to identify the risk, and these are some of the factors that the code sets out for identifying the risk. I think in a short spiel, it is about consulting with your workers, identifying the areas within which risk and harm can eventuate, and having systems in place to consider how those interactions can be managed. If it relates to interpersonal issues within the workplace, for example, looking at how jobs can be reassigned, people can be reassigned, tasks can be reassigned, and having a process and policy in place to deal with that. The next step is to assess the severity of the risk. Some workers are more vulnerable than others. Some workers come with predispositions that may lead them to be more susceptible to harm. Some jobs themselves, like I've addressed, can lead themselves to higher incidences of harm. The code requires a policy and a process in place to assess and prioritise the seriousness of risk in order to manage it, the nature of the harm, and how risks of various categories can be managed within the organisation. It is acknowledged that you can never take away risk. It's just about the management of that and having robust systems in place in order to manage that. The control of the risk is also very important. Everyone involved within a workplace has got health and safety duty to everyone else involved within the workplace. And the WHS Act also recognises, and this is important for organisations such as councils and others, that when you're dealing with outsourcing, you're dealing with contracting, you're dealing with subcontractors, All of those type of arrangements and procurement arrangements will affect how the work is done, and people within that may not directly be on your payroll can be the subject of risk, and depending on where they are and whose worksite it is, there may be duties owed to those people as well. And there may be more than one person that owes a duty, so it's important to understand within all your supply chains how this might operate as well. And so the issue of controlling risk is once you have identified what the risk is, assessed what the risk is, gone through the process of identifying the low and high risk things, it is implementing workplace practices to try and eliminate the risk. And if that can't be done, substitute the riskier ones with safer alternatives. Again, that might be reassigning people, reassigning tasks, shifting responsibilities, looking at the travel conditions for remote workers, also looking at situations for people who work from home and having that interaction. Do you have them come into the office? Are there other ways to do catch-ups? Are there other ways to have some face time to try and reduce the risk of psychosocial harm from being remote? And then there's also an obligation to do this in consultation with suppliers and subcontractors as part of a supply process for people that come onto work sites, people that come into workplaces and provide consulting services. Like I said, there may be more than one person that owes a particular duty to an employee. So it's important to keep that in mind, that just because you've subcontracted the work, you've got subcontractors on a particular site or a workplace, doesn't mean there's no duty owed to them. The review of your control measures is important. It's one thing to have a policy in place. It's another thing to ensure that it is being adequately maintained, that the risk measures are adequately being assessed. They change from time to time. If there's a change in work practices, if there's a change in the workplace, for example, if there's a change in worksite locations, all of these measures need to be considered on an ongoing basis. Again, goes with robust policies that they are constantly reviewed and monitored, not just drafted, filed and put in a cabinet, because if things happen 3-4 years from now, Safe Work is going to look at all of these factors as part of assessing any complaint that might be made. And so the response to psychosocial harm itself is also important. I just wanted to here touch on one case. So Safe Work New South Wales brought a prosecution against the Western Sydney Local Health District stemming from an incident in 2020. They brought the prosecution in 2022. It went in for hearing for 3 weeks last year. Ultimately, the prosecution was withdrawn, but there are some key takeaways from this. So what occurred was there were 2 nurses who were in a domestic intimate relationship who were working at the Hainsworth Mental Health Facility in Cumberland Hospital. Whilst they were working there in August of 2020, a patient absconded from the ward, and there was an investigation then undertaken as to how this patient absconded. So as part of that investigation, there was obviously interviews with nurses, the 2 nurses who were on duty. What occurred is that Safe Work New South Wales alleged that there was a mismanagement by the local health district in that it failed to apply its own policies to appropriate risk management of the investigation, and that the investigation process itself caused psychosocial harm to the 2 nurses who were under investigation because of the mismanagement of the investigation process. I mean, there was quite a tragic outcome in that the 2 nurses passed away, not as a result of this, but they subsequently both passed away. Notwithstanding that, Safe Work brought the prosecution because of the issues to do with the investigation and the complaints made by the nurses of the investigation process itself. There is no finding from a court because the prosecution was withdrawn, but it highlights the seriousness. This is an area that Safe Work is particularly invested in and is investigating, and there are a couple of other cases involving these type of allegations through Safe Work. and the risk of exposure to harm from the process itself is something that needs to be considered as part of the assessment of workplace harm. The second case I want to talk about is an Industrial Relations Commission's case from 2022 involving the New South Wales Rural Fire Service. There was a bullying complaint made in April 2019 against a member within the fire service. The RFS investigated it. As part of that investigation, there was a complaint then made about the investigation process. Safe Work actually issued an improvement notice to New South Wales Rural Fire Service because the investigation about the complaint took over 12 months. And so you've got someone who is a subject of a complaint waiting over 12 months for it to be determined about whether there is a valid complaint or not. RFS challenged that, took it on review. It went to the Industrial Relations Commission. The Industrial Relations Commission then considered what RFS's processes were for investigating bullying and harassment complaints and whether their management of that in relation to psychosocial hazards was actually adequate. The Industrial Relations Commission found that there was excessive delays in the processes for investigating the alleged bullying, that it then exposed the workers to psychosocial hazards because there was no action then taken to address either the bullying or the complaint about the bullying. And one thing the Commissioner said is, it is necessary to have an adequate policy, but it is insufficient to do so. A sufficient procedure requires proper implementation, including implementation within an adequate time frame. And so an order was made for the improvement notice to stand in an amended form, which acknowledged that RFS did not have an adequate system in place to prevent exposure to psychosocial hazards, the need for the completion of investigations in a timely manner, and an improvement process to monitor the investigation process itself. So just again highlights the importance of not just having a policy, but also implementing the policy in an efficient and timely manner, which, if not done, can itself lead to an allegation that there has been psychosocial harm caused. There's then the requirement as part of the code to support a safe return to work. Reasonable modifications as a result of responding to the injury. Consider whether going back into the same environment is itself a safe step to take. There's no hard and fast rule as to what is a safe return to work. It does very much depend on the particular circumstances of the employee and the workplace, but there are considerations that need to be had in relation to that. So that's what I'm going to say on psychosocial harm. I'm happy to answer any questions anyone might have now or later offline, if that's better. I will also now briefly address on the right to disconnect. So the right to disconnect was first implemented through changes to the Fair Work Act that were flagged in 2023. As of August 2025, it applies to all businesses and organisations. When introducing the bill, Senator Barbara Pocock, who was the chair of the Senate inquiry into the work and care, said that evidence provided to the inquiry showed poor sleep, stress, burnout, degraded relationships and distracted carers are just some of the damage caused by unbounded work. The pressure felt by workers, particularly when working remotely, has serious implications for mental and physical health and it increased work-related stress. And she also said the right to disconnect will give workers the freedom to switch off and focus on their personal and family lives. It will promote a healthier work culture that benefits workers and employees. And as we've seen, 1 in 5 complaints now relates to issues to do with psychosocial hazard, and it is by far the largest component of compensation that is paid out. So this is an important area of law that has been developed. The Fair Work Act has effectively been mirrored into the local government state award. I don't know if you can see all of that, but it is almost identical to what the Fair Work Act says. So employees have a right to disconnect from work during non-working hours. Supervisors and managers must respect employees' periods of leave and rest days and the right to disconnect from work during non-working time. Employees other than on-call employees are not required to read or respond to work emails or phone calls outside of their working hours, and the provision of a mobile phone or laptop computer to an employee does not mean they are on call or expected to be on call during non-working hours. I don't know how ardently any of us actually follow that, given I think most people here would be working from home in some capacity or another. There are obviously exceptions to that. Emergencies are one. Certain types of roles and positions require people to be on call. Certain types of tasks just cannot wait until someone returns from leave on Monday or whatever it may be. So there are exceptions to that, but they very much are the exception. They should not be considered the norm, and can lead again to complaints and investigation by Safe Work if it is considered an unsafe work practice and an unsafe workplace as a result from there. That's all I've got to say. Again, if anyone's got any questions, I'm happy to answer them now or offline remotely. It is a fairly dense topic to do with the Work Health Safety Act. This has just been a very high-level summary of it. So, if anyone does have any particular questions, I'm always happy to pick up the phone and answer any questions you guys might have. If you've got particular issues within your organisations or within council, again, happy to just jump on the phone, have a chat, see if we can help manage any of these issues.